Court calls the cases of the people versus Terry Probst.
Good afternoon, Your Honor. Raymond Cook for the people.
Oh, yes.
And Assistant Public Defender Natalie Pate on behalf of Mr. Probst. To my right, please state your name for the record, sir.
Terry Probst.
Thank you, Your Honor. Your Honor should be receive a green sheet. I'm respectfully requesting an adjournment. I was just able to make contact with him.
Counsel Probst, do you have the bond violation?
I do, Your Honor, and I'm also prepared to address
Okay, you ready to address it? Okay, go ahead.
So, Your Honor, as I was going to say, I just made contact with Mr. Probst this morning. He provided me with a new phone number. I was able to review the bond violation with him. When he was reviewing it with me, he told me that he went to community corrections on December 29th. I did then email Ms. Dozier at community corrections, and she stated to me that this morning that she just had the front desk check in the sign-in sheet, and it appears that he did sign in that day. If
The 29th?
Yes. However, it was not his day, and he would have been turned away unless we received an order from the court. Obviously, since then, Mr. Probst has had a lot of missed tests and did not go back to report. I asked him why, and he said that when he went on the 29th and they told him he wasn't on the list, he was confused, did not come back. I advised him that that was the wrong thing to do, and he should have continued contact with him and gone back to community corrections. He did also, Mr. Probst, that is, provided me with a document from Home of New Vision that he says is from 2 days ago. That does, I just received this morning, Your Honor, so I apologize. I was unable to provide it to the court or the people in advance. But it states that he's working with a Marcus Pollard at Home of New Vision, working to help get him through access. They are waiting on a follow-up communication so he can proceed with the next steps in his recovery, hopefully to get into rehab. That being said, Your Honor, I do have the documentation as from the Home of New Vision from 2 days ago that Mr. Probst provided to me. He is willing to engage in community corrections testing. And I believe he is confused.
He's missed 15 tests.
That is true, Your Honor. Yes.
And the 2 that he took, which were actually in September, he tested positive for cocaine.
That is correct, Your Honor. And then he was in jail and released on December 23rd. And obviously, I acknowledge he has not tested since he's been released from the jail on December 23rd. But positively speaking, he has been working with Home of New Vision. He did go on the 29th. Again, he should have continued to go back. And I did advise him that that's what he's supposed to do. I would ask if the court would consider ordering him to go to community corrections today and possibly come back based on the test results.
I'll adjourn this to the 29th, 2026, 9 a.m. But at this point in time, the defendant needed to do something else. He has attorneys. He has all kinds of tools at his disposal. He has in his bonds revoked. Defendant's remanded.
Caitlin Quinn, Your Honor.
Judge, at this time, I have filed an appearance, substitution of attorneys, and an order for substitution, and a request for adjournment today because I was retained yesterday to get discovery from the defender's office.
All right. Without objection. Probable cause conference. Will January 29th work for you, sir?
Yes, it does, Judge.
January 29th, 2026, 9 a.m. Bond continued.
Well, Judge, wait, may I address that? Because she's still...
Go ahead. No.
The bond on the ROA says personal, and she's still in jail.
Hang on. Check.
So I was confused why she would be there.
Yeah, Emily's looking right now.
I have it. I have it personal on the page. Yours shows what?
Right, yes. Which we have no objections to other than letting her go.
Is this her only case?
Yes, Judge. She has no priors.
Does she have a bond? But it doesn't say she's here on the bond, right?
While on bond, she's been testing. Her last test Thursday was negative. First test came back positive, and she said
She
that's
did
good,
have a violation
that she,
from January 7th.
that she, is that the one you appealed, the January 7th one? And I think that, and she appealed it, and I don't know if they got the appeal results.
Okay,
she planned
so
on
here's what I have.
Okay.
And the reason why she's in, her bond must have been changed. Did I issue a warrant on this? Or is she being held on that? Being held pending. Have you seen the bond violation?
I know that she tested positive, Judge.
Oh, she did.
Yeah, that's what they say, and then she appealed that. And those results are not back. And she tested negative last week when she was arrested on Thursday, and that was negative.
When did she? So on December 30th, you're saying there's a test after that one?
She indicates to me when you were incarcerated on the 8th,
When I got into jail.
which she was taken into jail on the 8th. Were you out on bond before that?
Just recently, last Thursday, when I tested and got into jail.
Right, that's when you tested.
Yes,
And
that's when I tested negative.
is that the only test? That one was negative.
Yes.
Which one was negative?
She says when she went in on January 8th to the jail that one came back negative. But then there was one. Why would there be one prior to that? Were you already on bond?
Yeah, she was already on bond. She
Okay.
was supposed to be testing. And just so counsel's aware, on December 23rd, she tested for numerous things. Well, she was positive for THC, which I don't think she has a card for.
She indicates she does have a card, Judge.
Okay, she didn't present it to them, but there were other things.
Not the card.
But I don't think she has a card for cocaine.
No, Judge.
Okay.
She is
She
on.
doesn't have a card for cocaine. And if that's not bad enough, that was on the 23rd. On the 30th, and I'm getting older, so I don't know. Do they have a fentanyl card? Because that's what showed up on that date.
That's why I can test it.
That's the one that she contested.
That's the one she's contested. So
Yes.
not the cocaine?
No, Your Honor, but she indicates she didn't use after on bond. She used immediately before bond. And I believe that was 6 days later.
She used the cocaine before she was placed on bond.
That's what she indicates to me, Judge.
Is it?
Yes, sir.
So when was December 17th, and it's showing up on the 23rd. Some good stuff.
What? Okay.
Yeah, and right. I revoked her bond last time she was here
Okay.
because of those tests.
Very good.
I am not inclined to change it at this point. It's going to sit where it is.
Well, Judge, if I may,
If somebody needs to, it's going to sit where it is until I get the results on the fentanyl. If she's contesting this, there's fentanyl in her system.
okay.
What about my last test from when I got into
Yeah,
jail?
what about the jail test on the 8th?
What?
What about her negative jail test?
I don't know. I don't have a report on the jail test.
Oh,
And I don't know what kind of test that was. I mean,
the
I don't
urine
know.
test?
Yeah.
The urine. So I'm assuming it was a drug panel.
It was like
Right, but I don't know if it went over through our system at community corrections. I don't have a report on it.
Right.
So I don't know if it was clean or whether it was or not.
But she would continue to test, Judge, and I believe she would continue to test negative.
She had 3 tests, and 2 of those tests, absent her prescription medications, 2 of those tests were dirty for something. I'm not changing my decision. I will take a look at it again if I get that other test.
Okay.
Or whatever. If I get the other test that she says she took, if it meets with the certain standards, or if I'll look at it. Or if the results of the challenge to the fentanyl comes back, then I'll take a look at that certainly also.
We'll address that on the 29th, then, Judge.
Yep.
Well,
Okay.
thank you for your time.
Thank you.
Mr. John Brown, who stands to my right. What's your name for the record, sir?
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor.
Did you
We
explain
did
all of
go
that to
over
me?
that. Yes,
All
we
right.
did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Could I have him sworn, please?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay. I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes,
and because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking.
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so you were in possession of a controlled substance that you shouldn't have been in possession of, correct?
Yes, sir.
All right. Then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take
that take plea to the higher the
All right.
charge.
Sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
10 a.m. Washington.
February 12, 2026, 10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation.
He's been a
jail
week on that violation, and
jail
the
week on that
basis
violation.
of it was two missed tests,
Basis of it, as well as I believe a test that was a positive for THC. I have spoken about this to my client. He of course admits to the bond violation. He did appear knowing that he was likely to be remanded on the bond violation. I do not believe him violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend, ages 16, 14, ages 3 and 11 months. He further has full-time work. He further has full-time work flooring. He's a finisher. He's a finisher. He's reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands orders. He understands he cannot have a single more. My understanding his positive test didn't have anything else positive besides the THC. He's willing to go on tether. He's willing to go on tether. He'd be willing to do house arrest. He'd be willing to do house arrest. Likely not. Advise him that is likely sanction the court would issue. However, he understands he's not to do substances. He needs not to do substances. He needs to.
I'm not going to change any bonds. He's going to need to talk to the probation department. And then in Judge Wisdom, Washington's decide to change his bond.
Understood, Your Honor. Understood, Your Honor.
Your Honor, first, I understand you say you're not going to change my bond. I just want to apologize to the court. I just want to apologize to the court. I just want to apologize for my ignorance and not knowing that I was supposed to go over there. I really need to get back to work. I really need to get back to work. Like I'm down. I'm down. I'm willing to go on tether. I'm willing to whatever. I just want to be able to get whatever. Get back to work right now. Get back to work right now. My girl's not working at home. I got 4 kids at home. Very high rent. Very high rent.
Okay, sir. What I've indicated in your counsel knows how to get through to 14B. They can contact 14B. They can contact 14B and get to Judge Washington. And then get to Judge Washington. But at this point, I'm not changing. Your Thank you.
Thank you, Your Honor.
Court calls case people versus Jalisa Roberts.